Beautiful people, it's me, Pamela, on my YouTube. Cho, no, what's the T? Siyahlaziya. Guys, imagine Thabo Bester no Nandipha. They lost the case. It was actually struck off the roll. They were just like, no, please. And you know what's crazy though about it? The Netflix was just about to premiere on Netflix. So they were just like, we can't help you. And ngapha on Nandipha manje babakhe, I'm sure Thabo Bester is where it's just like lo mkhulu lo ubethwenzani mara ezongifakela amehlo. You know? Umdala guys but they must just leave the guy. You know, he's old. So kwaphela kanjalo guys ngabo, it was sad and all, but what was supposed to be done, because also that arrogant lawyer Thabo Bester who was busy saying it hasn't been proven in court ukuthi he actually did escape from Mangaung prison. Are you serious, guys? No, that guy, I was just like, now, shouldn't have said those things. Just concentrate ekutheni bangakhulumi ngoThabo Bester when they're trying to do the Netflix thing. They mustn't mention their names and all of that. But I guess it's in Leando, it's Beauty and the Best. Guys, I'm just like, you know what? It's sad and all, but what can we do? You know, they don't have those powers. And you must also, they must actually, Nandipha and Thabo Bester pay for the costs of everything that was happening in that court. Imagine, guys, I was just like, wow.
Mr. Bester has claimed the equality issue was not addressed and is simply bad in law. In both matters, information about the doctor and Mr. Bester is firmly in the public domain. In fact, it has been set out in judgments in the bail application and the appeal against the bail, and in the High Court and in the judgment of the Supreme Court of Appeal. Never called by its name by the applicants, but the prior restraint, which is the correct defence, has been addressed by the SCA in the Media Television Pty Limited trading as ETV matter versus the National Director of Public Prosecutions 2007 in brackets 5 SA 540. As already stated, this is the matter that this court must follow. The principle is set out. The court went as far as to say that prior restraint can only be granted if the prejudice is demonstrable and substantial. It is a real risk that it will occur. Speculation, as argued in this court, is not sufficient. I am therefore satisfied that this application too did not comply with Rule 612 in that it did not address substantial redress, and in fact there is substantial redress in due course. For that reason, this matter is also struck from the roll and the applicant is to carry the costs. The court will adjourn.